Yes.
May I please the Lordship? Lord, I have prayer in item 13, my Lord. Item number 13, my Lord, 1-3.
Yes.
Lord, in this case, my Lord, the record pertaining to his younger brother was called for, my Lord. That has not come, my Lord. Lordship will kindly fix it in the next Monday, my Lord, if possible, my Lord.
Sunday. Okay. Both sides are represented. Mr. Z. Ahmad, the counsel for the petitioner, submits that the records of another reference in respect of his brother is not reached. So accordingly, prays for an adjournment. Prayer is allowed. Next list on, give it next Monday.
16, my Lord.
Next list on so and so. The registry shall issue a reminder for the records. Okay.
Deeply obliged.
May I please, Your Lordship? I'd like to mention item number 5, Lordship. With Lordship permission, I want to withdraw this petition and with a liberty to file afresh. There is some defect in the petition, Lordship.
Okay.
Pages are missing.
Okay. Both sides are represented. Ms. D. Ghosh, learned counsel for the petitioner, submit that there is some inadvertent error in the petition. So accordingly, she prays to allow her to withdraw the petition and to refile again. So prayer is allowed. Matter is dismissed or withdrawn with liberty as prayed for.
Deeply obliged, Lordship.
I also same, in view of as a common order. In the IA you have defect.
No,
So
no, only in the read petition.
but it has to
But
go
if we
together.
withdraw, I'll file both the petitions.
Item 1 motion to give.
Yes, item 1.
Probably report dipsy mileage.
Simple.
correction করে একটু permission লাগে না।
The 25th week চলে আসে নাকি নাকি? হুম? বাহ। My lord. Yes, yes. কি করে পারমানেন্ট কথা না বলি কিন্তু একবার মতো ভাই বুঝে যদি সুবিধা পাই বাইবেল বলে কিছু ইয়ার তো একটার মধ্যে 26 একটার মধ্যে 26 4 এটা তার 26 পাইছে এটা কি কইছিলে কনসেন্ট কোথায় আছে মাই লর্ড
As you read the opinion,
মাই লর্ড
in view of the legal prescription,
মাই লর্ড
the doctors do not say anything,
বাট মেডিকেলি
but they say that it can be, she can withstand the medical
ভাইবল
procedure. So therefore, we think we'll use our extraordinary power in this case and
Why
direct that, that the medical board be constituted and then they will do it.
they will do it. And then because they are apprehension, that as per law, it is not permissible.
Yes,
But medically, it is viable.
yes,
It is viable.
it's viable.
Court of law. এইটো 24 চলি আছে। চাই পেলাই opinion দিছে। It is fulfilled. Section 3 fulfill কৰিছে।
To act to the medical termination of pregnancy. Heard Mr. T.J. Mahanto and a senior counsel, assisted by Ms. P. Sharma and a counsel. Uses a senior counsel as well as Leonard Amicus Curie appointed in the matter, assisted by Ms. P. Sharma and counsel. Also heard Mr. D. Nath, Leonard senior government advocate, appearing for the respondents. Next one. This suo motu writ petition was registered on the basis of a news article appearing in the Times of India dated 29/11/2024, by which it came to the notice of the court that a minor girl was within bracket inverted commas X was at the relevant times 14 years of age, stated to be 14 years of age, was gang raped by 7 people, including 4 minors, at a location in the district of Tinsukia. And on a full stop, as per the newspaper report, the victim X was 23 weeks pregnant at that time. Full stop. In view of the minority of the victim, there is an apprehension that the unwanted pregnancy could lead to a substantial risk to the life of the victim, as well as the unborn fetus, FOETUS. Full stop. Accordingly, next para, accordingly, taking note of the provisions of Section 3 and 4 of the Medical Termination of Pregnancy Act, 1971, and in light of the decision of the Supreme Court of India in the case of A versus State of Maharashtra, within bracket 2024, bracket close 6 SC 3 to 7, comma, An administrative request was made to the secretary, District Legal Services Authority, within bracket DLSA, bracket DLSA for short, bracket closed, Tinsukia, full stop, through a lady paralegal volunteer, the parents of the guardian of the victim X was approached, and they expressed their interest for a medical termination of the unwanted pregnancy of X. Full stop. At the relevant time, when the Secretary DLSA, along with paralegal volunteers, had visited the house of X, she was shifted to a certain shelter home. So that they visited the home on 3/12/2024. They was removed, therefore, in the morning of 4/12/2024, the said paralegal volunteer, along with the secretary and other staff member of the DLSA Tinsukia, visited the shelter home and met X, and her statement was recorded, whereby she has expressed her willingness for the termination of the unwanted pregnancy. Full stop. Next paragraph. This suo motu petition was listed on 5/12/2024. We also say that as per the report, and previously, that as per the report of the secretary, DLSA, Tinsukia, a police case within bracket particulars withheld that has been registered under section 376 capital DA oblique 506 IPC, read with section 6 of the POXO Act, 2012. The next matter was listed on 5/12/2024, on which date, upon perusal of the report of the secretary, DLSA, Tinsukia, a direction was issued that the medical board, as provided under section 3 within bracket capital 2 capital D bracket close of the Medical Termination of Pregnancy Act, 1971, as well as the district level committee in terms of the proviso to section 4 of the Medical Termination of Pregnancy Act, 1971, including the chairman, Child Welfare Committee of Tinsukia district, were required to have the victim, X, examined by the medical board and to report as to whether it would be appropriate to have the unwanted pregnancy terminated, with special emphasis to the risk involved in such a procedure. Full stop. Next problem. Next one. The learned senior government advocate has produced a forwarding letter of the Child Welfare Committee, Tinsukia, dated 7/12/2024, along with a report of the Joint Director of Health Services, Member Secretary, District Health Society, Tinsukia, dated 7/12/2024 in a sealed cover. The contents of the clinical examination report after masking the name of the victim, the names of her parents, and the names of persons who were associated with the examination, as well as the place where the examination took place, to prevent inadvertent disclosure of the identity of the victim, inverted commas, X, is extracted below. All these names mask. Full stop. Next one. From the above, hearing before extracted report, we take note of the fact that as per the opinion of the medical board, within bracket MTP related bracket close, District Tinsukia, the victim X is reportedly fit to undergo any obstetrical procedure, OBSTERICAL, obstetrical procedure. However, in view of the fact that under the Medical Termination of Pregnancy Act, 1971, termination of pregnancy of 24 weeks within bracket plus is not allowed. No opinion was expressed on the termination of unwanted pregnancy. Full stop. In this connection, we also take note of the fact that as per the opinion of the clinical examination report, opinion expressed in the clinical examination report, the duration of on clinical examination, the duration of pregnancy appears to be 26 weeks. And as per the USG report, ultrasonography report, the duration of pregnancy appears to be 23 weeks, 4 days as on 11/11/2024. And accordingly, on 7/12/2024, the duration of pregnancy is calculated at 26 weeks, 1 day, with a possibility of variation of plus/minus 14 days. Next one. The learned amicus curiae has submitted that there are certain degree of risk involved in every procedure for medical termination, and he has further pointed out that the estimation of the duration of pregnancy is 26 weeks. And full stop. Therefore, comma, he urges that although the victim stated to be fit to undergo any obstetrical procedure, if the court allows such procedure to be adopted, the medical team should be so constituted that experts in the field should be requested to do the procedure. Full stop. Next para. We see that you don't. We say that you don't. In view of the prescription of the MTP Act, you don't say anything, but you're not adverse to allow the state to undergo the procedure. Correct? Next para. Next para. The learned additions, the learned senior government advocate has submitted that in view of the prescription provided in the Medical Termination of Pregnancy Act, 1971, he is unable to concede to the prayer made by the learned amicus curiae for termination of pregnancy. However, he has submitted that as per the clinical examination report, there is apparently no complicacy reported. Next para. Next para.
হাইকোর্টে রেজিস্টার দেন সুপ্রিম কোর্টে দিস ইন্ডিপেন্ডেন্ট এখন লিখে দিলে তাই হেরিটেজ করে রিভিউ হবে না Magazine সুপ্রিম কোর্টে দিয়ে দিয়েছিল class
The the court is conscious of the fact that the victim girl is a minor, aged about 14 years, and she is presently carrying an unwanted pregnancy of more than 26 weeks. Therefore, court is conscious of the fact that that at this stage, there is a threat of life to the victim X, if termination of pregnancy is carried out at this stage. Full stop. However, comparing the present situation with the risk that the victim may undergo at the time of delivery at full term of pregnancy, the risk factor appears to be same at the present stage as well as the risk that would be involved at the time of delivery of at full term of pregnancy. Full stop. Next paragraph. We've also examined the question arising out of the prescription as provided in the Medical Termination of Pregnancy Act relating to the termination of pregnancy. Full stop. In this connection, on examination of the materials on the record, it is seen that the medical termination of pregnancy is sought for in respect of the victim, who's now stated to be 15 years as per the clinical examination report. Full stop. We also take note of the fact that the pregnancy is alleged as a result of gang rape which the victim had faced had suffered by 7 people, including 4 minors. Full stop. The victim is not even able to say when she had her last menstrual period, and that it is a fact that she did not menstruate for last 6 months, and therefore, as per the opinion of the High Court of Bombay had refused permission for the termination of unwanted pregnancy which the victim therein had suffered due to sexual assault. Most of in the said case also, the victim was aged 14 years. First of under the circumstances, taking note of the risk situation which the victim was facing with 24 pregnancy to the victim. Don't sit down. Comma. Also took note of the risk which is involved at the at the at the time of delivery of the full term of pregnancy. Observed and held as follows. para 9. 9 to 12. Next para. We are also conscious of the fact that the said order was passed by the Supreme Court of India in exercise of its power, its power and jurisdiction under Article. By invoking the provisions of Article 142 of the Constitution of India, full stop. In this case, the unwanted pregnancy is now at 26 weeks. And the degree of risk which is involved in every procedure for medical termination of pregnancy at this stage or at this stage of delivery at full term of pregnancy would be same. Full stop. Therefore, the court is of the considered opinion that this court would not be powerless under Article 226 of the Constitution of India for the medical termination of pregnancy being directed. Next para. Accordingly, we provide as under number 1. This will be done where?
Immediately provided. Immediately provided. Immediately provided. That I recommend.
But we have not.
Hmm?
That we have not.
Huh.
The Honorable Court passing order.
Well, it should be immediately because time is basically.
No, because can she be, because we what do you call, practically we don't know about the situation of medical what do you call, facilities in Tinsukia. Either she be shifted to the Dibrugarh Medical College, which is the closest.
If facilities are not up to mark in the Tinsukia.
They will examine, the medical board will examine if there is any hospital, either government hospital or a private hospital in Tinsukia, she will be facilitated there. And if not, she
Then
will
Dibrugarh,
be
Dibrugarh.
shifted to Dibrugarh.
It's not forced makeup. That question of expenditure.
Because otherwise also the state will have to bear it.
Have to be.
Arrangement of funds, it may take time.
No, what we are saying is that you examine, let the board examine. If they, because the officers of the board are your government officials only. So you can ask them if they think that doing there would be better. They would do it, otherwise shift it to the Dibrugarh Medical College.
So that option may
Madam.
Because expenses, whether you do it in the medical hospital or in the private hospital, would almost be same.
Look, I'm not on that.
Ah.
I'm on the procedure.
It's okay. We are providing both. We are giving both options to you. Number 1, that the medical board within bracket MTP related back to district Tinsukia, along with the child welfare committee, district Tinsukia, are requested to immediately constitute a team for undertaking the medical termination of pregnancy of the minor within inverted commas X, in respect of whom the report of medical board dated 7/12/2024 has been forwarded to this court. Next para, subpara, number 2. All necessary arrangements shall be made by the state. No, next para, number 2. The said medical board shall examine as to whether they would prefer the. We will also examine the facilities available in the the government public civil hospital at Tinsukia or any other private hospital or public nursing home at Tinsukia for undertaking the said procedure, full stop. It is also provided that in the event the medical board does not find the facilities in the district of Tinsukia to be adequate, comma, the state would make arrangements for the transportation of the minor victim X to the nearest Dibrugarh Medical College and Hospital, as well as for a return home after the completion of the procedure. Next para. The state would bear all the expenses in connection with the procedure and all medical expenses required in the interest of the safety and welfare of the minor. Full stop. Next para. Subpara. The state shall also provide and extend all facilities and help for further medical care, comma, post termination, comma, if any required. Full stop. This is ordered to ensure the best interest of the minor. Full stop. Next para. The district authorities shall also take the help of a counselor for the minor so as to assist the minor in the preparation of for mental preparation of to undergo the procedure, if so required. Next para. Achha, in these orders, do we have to write anything about there's a offense made out under the Medical Pregnancy Act, and therefore we say we'll have to do we have to say anything or we don't have to say anything in the order? This MTP Act prescribes a punishment. Do we have to say anything or we don't have to say anything since it's a judicial order?
Yes.
You are doing something in compliance of that.
Yes.
So no observation is required. Huh?
Considering the special tax and circumstances.
Next para, as next main para, as this as the medical termination of pregnancy would be carried out in terms of the orders of this court, comma, it goes without saying that
Because Supreme Court is by accessing 142.
the penal provision of the Medical Termination of Pregnancy Act, comma, 1971 and rules framed thereafter would not be attracted. Next para. The learned senior government advocate
In fact, my lord, in 2024 judgment, that is Apex Court has already clearly made that judgment.
we are conscious of that fact, but there 142 was
And
invoked.
142 or 226. So
So-
power is my lord.
So
Because in-
that's why
by-
in view of the urgency, comma, considering the tender age of the victim girl and the length of pregnancy, comma, the court is of the considered opinion that this is a fit case for ordering medical termination of pregnancy of an unwanted fetus, which would be in best interest of the victim X in view of a minority.
My lord.
Then add that next para. The learned senior government advocate shall expeditiously communicate the transmitted downloaded copy of this order to the Child Welfare Committee. It will be Child Welfare Committee.
Yes.
Child Welfare Committee, Tinsukia, as well as to the District Magistrate. District Commissioner Tinsukia. 1, 2, number 3, the Joint Director of Health Services Tinsukia, to do the needful for immediate compliance of the
My lord.
order. Next para. This matter after 10 days. This matter. Just calculate 10 days from today. It will be
Today is 19.
19th. Okay, 19/12/2022.
Deeply.
For submission of the submission of the
For submission of the status report.
Deeply.
Next para. The court master shall also provide a copy of the report of the medical board to the learned senior government advocate. As well as to learned senior counsel for the learned amicus curiae. Full stop. The said clinical report shall
Be a part of the.
be kept in the seal cover envelope and made a part of record.
Fine.
It will have it. Copy the dollar. After some time, just have this collected.
Get the copy of the order by.
I'll try to give it to you in some time.
Upgraded item for orders, item 17.
This was suspension of sentence.
Yes, we are challenging the judgment and order. And
Okay, then it is likely to take some time. We'll take it after some time because we have a lot of motions. We complete that and then take it up.
my lord, just a simple, I just wanted to inform the court. I'm standing here on behalf of Senior Counsel Z Kumar. He's currently out of station. So we have received the LCR and we have received the paper book. So kindly a date may be fixed for hearing. That's all that.
But then it goes after this winter vacation.
As your lordship sees fit.
Okay, let the court master take we'll give a date after some time. Then uh, both sides are represented. Mr.
PD Chaudhary.
PD
Chaudhary.
Chaudhary, counsel for the applicant, submits that he has received a copy of the paper book. Mr. All sides submits that the matter be taken up for hearing. Mr. Accordingly, list the matter for hearing on. Give a date after vacation. He'll give it after some time.
Obliged.
Mr. Just record is present. Mr. K. Bashir, APP for the state is present.
Upgraded item 18.
Oh, it should be, I made a mistake. It should be Guwahati High Court Legal Aid Committee.
Yes.
Okay. This,
Secretary Legal Service.
both sides are represented. Next paragraph. This matter has been listed pursuant to order, pursuant to the office note put up by the Registrar General dated 5/12/2024, comma, indicating that as per the order dated 29/11/2024, comma, cost of rupees 10,000 was required to be deposited before the member secretary, comma, Guwahati High Court Legal Aid Committee within a period of 15 days. Post of. It is brought to the notice of the court that the correct nomenclature of the Legal Aid Committee is Guwahati High Court Legal Aid Committee. Oh, sorry, Legal Services Committee.
Yes.
Post of. Next, accordingly, comma, it is provided that the directions contained in the order dated 29/11/2024 for payment of cost shall be read as the authority to whom the cost is to be paid shall now be read as provided in paragraph 9 within bracket Roman 1 shall now be read as member secretary. No, sorry,
Only
it will be
secretary, not
only secretary.
only
Okay.
secretary.
Shall be read as
Legal Service Authority.
shall be read as inverted commas, the Guwahati High Court Legal Services Committee, inverted comma closed. Instead of inverted commas, member secretary, comma, Guwahati High Court Legal Aid Committee, inverted comma closed. Next para. The time for payment of such cost is extended up to a period of 15 days from the date of this order. Consequently, the time for the petitioner to appear before the Superintendent of Police within bracket border bracket Bongaigaon is further extended to 4 further working days thereafter.
Paragraph 11
Post-
7 did.
Within Full stop. The direction containing paragraph 9 within bracket Roman 2 shall stand modified accordingly. Full stop. Next paragraph, consequently, comma, the time provided in paragraph 11 of the order dated 29/11/2024, comma, stands extended to further 7 days, 7 working days thereafter. Full stop. Next paragraph, all other conditions shall conditions as provided in order dated 29/11/2024 shall continue, comma, save and accept the extension of time as granted by this order. Next paragraph, this order shall be read together with order dated 29/11/2024 passed in WBC 1011 of 2024. Only 3 corrections,
Plus.
9(1), 9(2), and 11.
Yes.
Okay.
Oblige.
Let's just record the presence, Mr. F.U. Balvia, for the
Petitioner.
petitioner. CGC who's there? One. Mr. B. Chakravarti, CGC for respondent number 1 is A. Verma, Learned Standing Counsel for the FT matters representing respondent numbers 2, 5, and 6. And Mr. P. Sharma, Learned Additional Senior Government Advocate for respondent number 3. Mr. H. Uli on behalf of Mr. A. Ali, Thomas Standing Counsel for respondent number 4. Okay.
Oblige.
Item 2 for motion.
May please watch. Well, this PIL is being filed by 2 journalists. The issue is on probity in public governance and corruption-free government, good governance. Well, what has happened for 6 years, a serious case of corruption, money laundering, and income tax violation was being filed by these 2 journalists, and they pursued the matter. The first annexure is at page 33. It is at
What is the-
annexure A, page 33.
So what is the prayer here in
Well,
this?
we have sought our
Yes.
liquidation is that in terms of the Supreme Court's order, the Supreme Court has said that if there is apathy, inaction, and inertia, the 226 power and 32 can be invoked. In fact, in its latest judgment, the Supreme Court has said that the High Court is the best forum. So our prayer is, we want to know the status of the case. We never know what will happen if the status of the case says that inquiry after inquiry, nothing is in front, we have no. Secondly, I want to make it very clear, we are also not on his promotion. He is at present holding the post of chief engineer. And our thing is that we brought in the factual part. If I may just place the facts, that will be clear. In fact, this matter went up to the Supreme Court also, his service career. We are not on the career, we are on the influence which this person holds. Because he was the OSD to the former chief minister. And the Supreme Court has said that an officer could indulge in such manipulation and fraud that he jumps over 300 officers. Well, it is unheard of. So that's the observation of the Supreme Court. And after that, and this case was being registered in 2017, we relentlessly, religiously proceeded. We have absolutely no interest in it. It is an interest in the public domain. And in fact, the Supreme Court in the Shofal case has laid down 3 principles. The concept of PIL now has got 3 phases. The first is the human rights angle from 80s to the 90s. From 90s downwards, it is the environmental part. And the third is now probity in public governance. And in fact, it started with the famous Vinit Narayan case, the Jain Hawala case, where the Supreme Court intervened and directed that the CBI should be insulated from interference. So in fact, if I may take your lordship to certain annexures, your lordship will find that at page annexure A at page order dated, application dated 31/8/2016, I first given a complaint to the Vigilance and the Anti-Corruption Department. Sir, can I read, Lordship?
No, not to cut, you can just give a gist.
Yes.
Because
Well,
today we also have single bench,
Okay.
a long list. So
Well,
Then I would like to, let's just one order of this honorable.
let him complete first. Let him complete first.
my lord,
You have anything to say on maintainability?
Yes.
What is that?
Lord, can we see the order dated 22/5/2020?
We have taken note of that.
If today for him, if to satisfy this honorable court has regarded the maintainability of the state.
only one thing my learned friend will have to clarify. He is appearing on behalf of the PWD department. We have made the private respondents a party also. Well, if he talks about the maintainability part to put a fetter on my submission of getting a notice, then he will also have to show that he is espousing whose cause, because a state cannot say that we don't want a credible investigation to continue. Because the Supreme Court's all judgment talks about a credible to instill confidence in the public about the investigative process, that is the vigilance. So he cannot now take a view that he being a state council, he cannot oppose that, because in fact, if he is talking about good governance, he should support by PL. And as your lordship knows, it's a collaborative litigation. And it has a long checkered history in India.
That depends. If the vigilance is taking up the matter, then he would be aware of it.
No, my lord, one paper document I'll show. When I came to this court, I filed again an RTI, because on the initial stage, initial day, the Honorable Chief Justice took up the matter. We could get an RTI file in the Vigilance Office to know the status of the case. The Honorable Chief Justice also gave us a cue. Well, there they say in the month of March, we have given an additional affidavit. The investigation is still on. And in fact, one document I won't trouble your lordship, 169, page 169, a very vital document of the selection process, where the Chief Secretary of Assam calls for a vigilance report of his case, but nothing was to be found. Lordship will take up page 169. I just won't trouble your lordship. But this was the selection meeting, which is at 168, by notes of the selection board meeting for selection of officers for promotion to the rank of Chief Engineer PWD from Additional Chief Engineer, held on 28th of January 2024. Your lordship will come to serial 11 at page 169. Next page. The selection, page 169, serial 11. The selection board observed that there is a regular inquiry, which is a subject matter now, of 17 under progress against Sri Devojit Das, who is at serial 2 in the zone of consideration Assam, as intimated by the Home Political Vigilance Department, Assam, but details of the case and the alleged charges are not furnished by the DEM, and hence the selection board asks the PWD are to obtain details of the RE and to place the same before the next selection board. The reasons are very simple, because there's an OM of the Assam government which says that when a promotion can be withheld, a promotion can be withheld of an officer under three situations. First, whether he's under suspension. Second, whether if there is a criminal case pending against him. And third, in respect of charge sheet which has been issued. In fact, the charge sheet, the fact the charge sheet was not issued in a departmental case finds a reference of my learned friend's submission in the court, because he comes to the court and says, my selection process is being stalled. The court says you can go ahead with it, but go ahead with it, the court never wanted that the criteria won't be followed. And the OM specifically talks about a situation when an officer is under cloud and when a serious case is pending. This is a serious case. Why? After a preliminary inquiry, prima facie materials are found out, they go for the regular, and then the next third stage is a charge sheet. Then the government has the power to either withhold promotion, to place the officer under suspension, or keep it pending, because the credibility of that post is there, because now he is holding a very high post. In fact, your lordship will come to page 34. At serial 5, lordship, the OM number 25th October 2004. It's at page 34, lordship. The OM date, yes, lordship. Well, this is I've given a list of the OM. I won't go through it. What are the situation an officer can be, promotion can be withheld? Well, it starts at page 31. The order OM is of 18 January 2013. Well, the operative part,
This
yes,
person is under the state service.
Malad, he is under the state service.
Now this page 34 you are showing us is a part of page 33,
Yes.
which is a central government.
No, Malad, what has
DOPT.
happened? The central government's notification in the personnel department, they comply with the central government's notification.
No,
on
there has to be
vigilance.
accepted.
Malad, in fact, this
State
is,
government will have to adopt.
yes, Malad,
otherwise there's no-
this is your lordship will find at page 31. This is an OM of the Assam government
Yes,
at 18 January 2013.
13, yes.
There, your lordship will find that in serial 2, if I may read, guidelines in respect regard were issued by such and such on 19 March 2008 in view of the guidelines for the grant of vigilance clearance to AIS officers. Department of Personnel, Government of India issued a letter dated 29 October 2007 and September 7, 2011 that has become necessary to issue following guidelines for compliance by all concerned for grant of vigilance clearance.
So this is all.
In fact, this Assam government makes a
No,
reference
that's
to this.
okay, but this page 33 is dated 2nd of November 2012.
Yes, well,
So-
I'm annexing because the central government's notifications are in reference with the personnel department's notification of 18 January 2013.
No, I don't know, because you'll have to show us.
Yes.
Unless the state government accepts it. DOPT circular may not be applicable.
My lord, in the, at least since I do matters of reservation, in the entire reservation issues in Assam, all DOP instructions on the constitutional provisions are being followed here. And the guidelines of Assam are in consonance with the central guidelines. Only the officers work in different situations. They work in center, we here. But in those cases, all central government guidelines on Article 16(4) are being complied here. And accordingly, Assam government issues OM.
No, we don't know, let us clarify. Mr.
Yes.
Nayak, what is your stand? You have this notification?
No, we have so far as personnel department is concerned, there is a separate OM for conducting regular inquiry, preliminary inquiry, that is one. Now, secondly, lordship, what he is saying is absolutely incorrect, lordship. The next step after regular inquiry is filing a FIR. Only thereafter, if something material is found, once success will be filed, otherwise it will be.
No, that is on merit. Just asking you to come to page 33. This OM of second level is 2/11/2012.
33 is not part of my plea.
No. He's not this 33.
Yes.
The document is now producing.
That has not been given.
You did not given here.
Well,
Give him a copy.
But there is another OM of
I will
2000.
come to up to my notice lordship, I will definitely reply on that lordship. But whatever he has submitted till now,
No, that is not very, we'll hear you. We'll hear you. Let him complete his part. Just give him a copy, otherwise he'll not be able to respond.
Dylan. Well, we could get it just.
You keep our copy. You see, we'll take it up after some time. You go through it.
So my respectful submission is that
this was issued by the Assam government.
Next page.
next to central laws.
This one.
Yes.
Is it adopted by the state government? That is the query.
The grounds are same lordship, this 1, 2, 3. In the Assam government notification
So-
also,
so
we have
same.
not placed the correct document. Here also lordship will find field on what situation promotion of a person can be.
No, we don't know. You see, here there is a reference to a different OM of union government. This is 2013.
Lordship, these 3 grounds was given by following the judgment passed by the honorable. These grounds are
Please,
same
you're not getting what I'm trying to say.
law.
Come to page 33.
Yes.
This is the OM of 2/11/2012. Correct?
Yes.
Now come to page 31.
Yes.
This is 18 January 2013. That means post
Yes.
page 33.
Yes.
Here you don't refer to this. So the query is as to whether the state government has adopted page 33. It may be same. Language may be same. I don't know. I'm not on language.
No.
I'm on the query whether this OM of 2/11/2012 has been adopted or accepted by the state government.
I will definitely obtain that instruction, but my specific answer to this is that only on 3 grounds promotion of a person can be equal. That is the.
We will hear you. Let him complete. Let Mr. Das
This
complete.
decision clearance is not, that is, in fact, that was cleared by this honorable court in respect of this.
No,
petition.
let him complete. Then we'll hear you. Mr. Naik.
My learned friend is a little bit confused on one point. Malad, I am not seeking any,
Dasi,
his promotion is not under challenge.
you got a copy?
Yes,
We have.
we have.
You have-
We have.
Okay.
Malad, the promotion is not, I want to show his influence because your lordship will come to the orders of the Supreme Court at page 131. Because to build up my case, I'll have to show the amount of clout, the influence this person holds and how he is stalling the entire inquiry for the past 7 years. That is my case. Lordship will come to 171, 131.
With that, how you are affected if you're not?
My lord, I am
even the-
affected. No, my lord, I have not come as it is not a personal interest litigation, private. It is a public issue on governance, good governance. PL throughout the country, the Supreme Court has allowed it. That probity in public life and good governance is a part. And if there is a failure, anyone can take it. In fact, in the Vinit Narayan case, the Supreme Court has said that investigative journalists should take up these matters. It is not that I have come and I religiously continue with for 7 years I am going. I have availed the statutory remedies. In fact, the Supreme Court in a case from Sikkim has said, I'll place it, that you don't come to the Supreme Court for that. High Court is the best forum. Because if you have availed the Supreme Court a statutory remedy, this is the case, statutory remedies, you can always have a case where the High Court is the best forum, not us. And this was a case of corruption against the Chief Minister in Sikkim. So Supreme Court turned it to the High Court. The Lordship paragraph, in fact, the operative part is at 18.
Yeah, fine. Como right in any policy. Support করবো লাগে বাকু লাগে বুঝতে পারবে
Para 18.
Yes, Lordship, if I may read. Hence, it is our conclusion that the petitioner's prayer cannot be granted because they wanted a corruption case to be investigated. This court cannot sit in judgments over whether investigation should be launched against politicians for alleged acts of corruption. The Supreme Court of India functions as a constitutional court as well as the highest appellate court. If the Supreme Court gives direction for prosecution, it would cause serious prejudice to the accused, as the direction of this court may have a far-reaching consequence, far-reaching persuasive effect on the court, which may ultimately try the accused. It is always open to the petitioners to approach the investigating agencies directly with the incriminating material, and it is for the investigative agency to decide on the future course of action. While we can appreciate the general claim that the efforts to uncover the alleged acts of corruption may be obstructed by the entrenched interest. Here we have entrenched interest. In this particular case, the petitioner would be well advised to rely on the statutory remedies. It is only on the exhaustion of the ordinary remedies that perhaps a proceeding can be brought before a writ court, and in any case, the High Court of Sikkim would be a far more appropriate forum for examining the allegation made in the present. Hence, the petition is dismissed. So, your Lordship will see that in the initial part of the judgment, the court, the writ court only, your Lordship sees interference in criminal matters, investigation, circumstances warranting interference, breach of fundamental rights. Allegation of corruption against the incumbent chief minister, held, writ courts can play a corrective role where there is apathy. In this case, there is apathy. There is obstruction in investigative process. We have also alleged that because of his influence, he can obstruct destruction of evidence or undue pressure from powerful interests when a specific violation of fundamental rights is shown. In all these circumstances, the courts can only play a corrective role to ensure that the integrity of the investigation is not compromised. Our prayer is very limited. We want the status of this case. We don't want how to proceed, what to proceed. That's not our function. So we know our limitation. And as regards his promotion, Mala, I want to make it clear. I have no case against his promotion. He has already got his promotion. The government has given it. But to build up my case, I will have to refer that in the selection committee meeting also, this inquiry came to the notice of the Honorable of the Chief Secretary, but they never gave the information. So I'll call upon the Vigilance Department, notice may be issued and a status report be. That is the thing I want.
Yes.
Because my prayer, I may read the prayer also.
You've seen that.
Yes, Lord. Over.
Like if your lawsuit goes for the order of 22/5/2024 lawsuit, one specific finding is there. Not may kindly see the fourth paragraph. Though the learned counsel for the petitioners is claiming that the petitioners are not aggrieved by the promotion of the Western number 12 on the post of chief engineer, but from the averments made in the writ petition, it appears that essentially the grievance raised in this PIL is regarding the promotion of Western number 12 on the post of chief engineer. So that was the specific finding of the division bench lordship. And on the basis of this particular finding lordship, a direction was issued. On that day, Lord Chief Justice was about to dismiss this petition. But on his prayer lordship, it was kept, proceeding was on lordship. And the finding last line lordship, learned counsel appearing for the petitioners has to satisfy this court on the maintainability of the PIL on the next date of history, on the basis of this particular findings, lordship. So what he is saying, lordship, what he is praying is contrary, is something contrary to the pleadings, lordship. That was the finding, a specific finding of the court. Now, if I come to the High Court rules, lordship. Page 488, lordship. Lordship, appendix 37, Lordship. Preliminary, I am coming to serial number 8, Lordship, part 2, page 489. Guidelines for screening letter petitions. Letter petitions raising or alluding to matters of public interest shall be entertained as letter petition, and unless directed by the Public Interest Litigation Committee, letter petitions under the following categories shall not be entertained as public interest litigation. Lordship, kindly see serial number 2, service matters and those pertaining to pension and gratuities. Lordship, why I am referring to this particular provision, Lordship? Because there is a particular finding that this matter relates to promotion of the petitioner to the post of chief engineer. Lordship, next I am coming to page 171.
This observation is based on which paragraph of the
I am
regulation?
referring to the judgment dated, Lordship, 22/5/2020.
No, it's there, but where is the corresponding averment in the writ petition, this PIL?
Lordship, in the entire petition relates to promotion of the petitioner, Lordship. He was appointed 1992. He was given promotion 2022. He override more than 100% while getting promotion to the assistant executive engineer. His promotion to the post of AC, his promotion to the post of chief engineer. Before giving promotion, vigilance clearance was not taken. These are all pleadings, Lordship. Entire pleading is on his, about his service record.
No, but what is, why it would be so bad just to dismiss the PIL? You see, if somebody has a police case or investigation going on against him,
That is the
And-
specific finding, Lordship, why I am referring to the earlier judgment, Lordship. Clearly states, though he is claiming something else, but pleadings relates to his promotion only. And it was on that basis, Lordship, he was directed to substantial maintainability.
no, but that's why we are asking. That's the precise point we are asking.
Lordship.
If there is a vigilance proceedings drawn up against a person from 2017, and if he is being regularly promoted, can somebody not point out this, that he has been promoted from time to time, and there is a vigilance clearance which has not been brought to a quietus?
Yes.
What
Lordship,
is-
promotion has been given by the state government after due consideration. And if I specifically refer to page 171, Lordship, I kindly see page 171. It is WBC 551.
Because is it not too, what you call, what you call, two different approach by the state government? For one, you have a vigilance inquiry, you don't promote him. For another, you take a decision and promote him. It's not a
Exactly to
case.
reflect that point of the Lordship, I am referring to.
Page 130,
Page 171.
171.
Also, this is WBC 551/2024 filed by the corresponding number 12 on page. Page 172. Paragraph 2. Lord.
Yes,
Paragraph 2. The petitioner is presently holding the post of additional chief engineer. Is the same person, Lord. In the Department of Public Works Road Department, by notification that is 11/1/2024 issued by the Special Commissioner, Special Secretary to the Government of some Public Works Roads Department, the gradation list of additional chief engineers PW was notified, wherein the name of the petitioner appears at serial number 2. It is the case of the petitioner that the person at serial number 1 in the same notification dated 11/1/2024 was already promoted to the post of chief engineer and he has retired on 31/1/2024. The case of the petitioner before the court is that the case should be considered for promotion to the post of chief engineer in as much as there are 5 vacancies available in the cadre of chief engineer. The further case of the petitioner is that the regular inquiry by number RE 78 within bracket 12 of 2017 is pending against the petitioner. However, till date, no such suit has been filed. This court on 12/2/2024 directed the Learned Standing Council PWD to take instruction whether such sheet has been filed in the said regular inquiry. Today, when the matter is called up, the Learned Standing Council PWD submits that no search sheet has been filed in the regular inquiry pending against the petitioner. Recording the submission made by the Learned Council, Standing Council PWD, this court is of the considered opinion that there is no further impediment on the part of the respondents to consider the case of the petitioner for promotion to the post of chief engineer PWD. Accordingly, the DPC is directed to consider the case of the petitioner for promotion to the post of chief engineer PWD within a period of 2 weeks from the date of receipt of the copy of the said order. Therefore, consequential order shall be passed by the concerned authority forthwith. With the above observations and directions, this petition is disposed. So it was to the notice of the Honorable Court, Lordship, and it was a specific
No,
direction passed.
You see,
by the-
what you call these orders are passed because of Janaki Raman's case,
Yes.
where it says that unless a charge sheet is filed or a departmental action is taken, till then you have to consider it, and then therefore the seal cover procedure will not apply.
Lordship.
Correct. Now, if you have a person against whom a vigilance inquiry is there since 2017, now we are in 24, 7 years. So for 7 years, the government does not have will to dispose it off. That preliminary inquiry is not being disposed of. And in the meantime, in 7 years' time, one would get 2 or 3 promotions. You see, please tell me, if somebody has to write a writ petition, requiring an inquiry, is it not necessary to say that because of the non-disposal of the inquiry, this man is getting promoted? So once a averment is made that he is being promoted, can it be said that you are challenging the promotion? Because in the prayer, it's not against promotion. It's the system which is working in respect of this person. There's an inquiry against this person in 2017. You don't close that inquiry. You could have said that, well, there's nothing in the inquiry, we close it.
Lordship, may kindly come to the prayer law. What is this prayer? Page 30, Lordship. A rate in the nature of mandamus shall not be issued to direct the authorities in the Vigilance and Anti-Corruption Department, Income Tax Department, procedure complete the investigation in regular inquiry number so and so for a free and fair investigation from the specialist. Where is the evaluation? Where is the finding that inquiry is not free? Where from he is establishing that fact law?
I don't get it. Please repeat again.
Lordship, he is praying for a fair and free investigation. Free and fair investigation.
No, that can't be a parameter, Mr. Nayak. Let us say that there is a heinous crime. Correct. In the presence of everybody, there is some crime committed. There are 10 witnesses to it. And the police says that, well, I did not get any material, and therefore I am continuing with the investigation. And the investigation continues for 5 years. Now, what would the public, opinion on this investigation? A murder takes place in broad daylight in the presence of 10 people. All 10 people are witnesses, eyewitnesses.
My submission will be in an appropriate petition with appropriate pleading. Lordship will definitely pass some order. But in this case, when Lordship, a specific finding has been observed, recorded.
We are taking note of that. Order to treat you, we are taking note of that. But we are asking you a question as to what is the parameter of somebody being inquired into on the basis of allegation of disproportionate assets or any other ground of corruption. what is the parameter adopted by the state? For how many years, according to your OM, it can be dragged? And you see, this is not the only instance where people have come to court for a fair investigation. Now, supposing there's I just said told you about this murder which takes place, 5 years, no investigation. Can somebody not come up and file a writ petition saying that for 5 years in a broad daylight murder could not be investigated? Therefore, please order fair inquiry. How can somebody say
Not if the complaint is already pending, he can pursue that complaint. But
He
lordship
can't.
will at the same time.
you tell us how does somebody interfere in a vigilance inquiry? Tell us the law. Tell us the law inquiry.
At the same
vigilance
time,
inquiry.
lordship will also see the credentials of the petitioner.
What?
Lordship will also see one of the petitioner, lordship is a ticketer of the department, lordship.
Oh, those things doesn't matter to us. You see, very simple reason. It was on the basis of a postcard given by Charles Sobraj,
Yes.
who was himself a detainee. Sorry, what do you call a criminal,
Criminal.
and even his letter was taken up. So in a case of an inquiry and vigilance, you don't need to establish the credentials. He may be a worst man in the earth.
Yes. You can have a.
We'll take it from you. We'll record it that according to you, according to the department, the petitioner is the worst person in the earth. But why can't he come and to the court and say that this matter is being?
Let me. Let the department, I mean, the government lordship have the status of that inquiry.
You are appearing for the
I'm
department.
appealing for the PWD. Because
PWD.
he is concerned with the promotions of the promotions law. That is why I'm submitting.
No, promotion, Mr. Das is
I'm
giving
not
a statement.
concerned with, just now he said I'm a thikadar. Thikadar cannot be now an officer. I say probity in public life and in fact.
It's okay, we record your submission that you're not pursuing that, you're not agreed by the promotion.
Because I have brought in the promotion to show even the Supreme Court has said that this person is manipulated. My fear is that because of his influence and clout, he could stall the proceeding for
Take a
7
short break
years.
and come back. Just take a short break.
In fact, yes. Well, one judgment I forgot to give, Lordship. Can I place it
Just
after? Oblige.
Yes, Mr. Nayak.
Paragraphs in the filing process.
Yes.
If Dr. Thompson, paragraph 15, is great.
paragraph?
Chapter 18, Lordship.
18.
24.
24.
Yes.
Yes.
That the petitioner begs to state that immediately after passing orders in WPC number 551/2024, the respondent authority on 5/3/2024 passed orders of promotion of the respondent number 12 to the post of chief engineer without resorting to a still cover procedure or could have waited for conclusion of inquiry required when the regular inquiry is pending against him. It stated that the order of promotion was passed by Sri Sandan Sharma, Special Commissioner. He has been named by party, the commission.
The party.
Special Commissioner and Secretary PWR, against whom the petitioners have already lodged complaints before the Chief Secretary. Then if Lordship comes to paragraph 20, the petitioner therefore found that there was total inaction on the part of the respondent authority. At least no effort has been made to find out an independent inquiry verification of the alleged anomalies raised in the complaint. Face illegalities pointed out from face of the record did not proceed further to investigate the matter. The petitioner raised complaints before the Chief Secretary, Government of Assam, by filing detailed complaints dated 22/5/2020. But till today, there has been no effort by the government to look into the matter, pro and independent, unbiased and free. In fact, Lordship, this complaint was lodged requesting the Chief Secretary not to promote him to the post of Chief Engineer now. This complaint has not been annexed, but this is a complaint basically paying for not to give him promotion to the post of Chief Engineer. No, Lordship, basically what I am arguing, Lordship, one judgment, Lordship, I would like to place, Lordship. That is 2004 3 SCC 363.
2004 3 SCC.
2004 3 SCC 363.
CC. Page Kiman 363. The party name. Party name to place.
Please give the citation again.
2004 3 SCC 363.
2004.
3 SCC 363.
Name of the parties.
It is Dr. B. Singh versus Union of India and others.
No, 2004 3 SCC 363.
Yes, 363. I'm at paragraph 40.
Paragraph 40.
140.
Yes.
Got it. There you go. The court has to be satisfied about A, the credentials of the applicant, B, the prima facie correctness or nature of information given by him, and C, the information being not vague and indefinite. The information should show gravity and seriousness involved. Court has to strike a balance between two conflicting interests. One, nobody should be allowed to indulge in wild and reckless allegations, besmirching the character of others, and two, avoidance of public mischief, and to avoid mischievous petitions seeking to essay or oblique motives justifiable executive actions In such case, however, the court cannot afford to be liberal. It has to be extremely careful to see that under the guise of redressing a public grievance, it does not enforce upon the sphere reserved by the Constitution to the executive and the legislature. The court has to act ruthlessly while dealing with imposters and busybodies or meddlesome interpolers impersonating as public spirited holy men. The masquerade as crusaders of justice. They pretend to act in the name of pro bono publico, though they have no interest of the public or even of their own to protect. Then lots
Para 18.
Paragraph 16.
16, okay.
Paragraph 16 Lord is noted supra. A time has come to wait out the petitions, which though titled as public interest litigations are in essence something else. It is shocking to note that courts are flooded with large number of so-called public interest litigations, whereas only a minuscule percentage can legitimately be called as public interest litigation. Though the parameters of public interest litigation have been indicated by this court in a large number of cases, yet unmindful of the real intentions and objections, court at times are entertaining such petitions and wasting valuable judicial time, which, as noted above, would be otherwise utilized for disposal of genuine cases. Though in Duradhan Sahu, Dr. versus Jitendra Kumar Misra, this court held that in service matters, PIL should not be entertained. The inflow of the so-called PILs involving service matters continues unabated in the courts and strangely are entertained. The least the High Court could do is to throw them out on the basis of the said decision. This tendency is being slowly permitted to percolate for setting in motion criminal law jurisdiction, often unjustifiably just for gaining publicity and giving adverse publicity to the opponents. The other interesting aspect of it is that in the PILs, official documents are being annexed without even indicating as to how the petitioners came to possess them. In one case, it was noticed that an interesting, and I'm skipping this portion now, and then coming to whenever, come down slowly, a little bit, lots of one word start from whenever. Whenever such frivolous pleas are taken to explain possession, the court should do well, not only to dismiss the petitions, but also to impose exemplary
Just come down.
exemplary cause, as it prima facie gives impression about oblique motives involved, and in most of the cases shows proxy litigation. Where the petitioner has not even a remote link with the issue involved, it becomes imperative for the court to lift the veil and uncover the real purpose of the petition and the real person behind it. It would be desirable for the court to filter out the frivolous petition and dismiss them with cause as aforestated, so that the message goes in the right direction, that petitions filed with public motive do not have the approval of the court. Now, if he is so interested with the inquiry lordship that is conducted by the other department of the government lordship, why he had made somebody in the PW department, a person, the commissioner of the PW department, party, naming him personally, individually naming him lordship? What was the requirement? He is not involved with the inquiry. He is involved with the promotion.
Who is he?
Serial number 3, lordship, respond number 3. He is the commissioner of the PW. He is not conducting the inquiry.
Yes.
Serial number 4, he is not conducting the inquiry. Serial number 5, Secretary Public Works Department, he is not conducting the inquiry. Inquiry has been conducted by the Home Department. He is only trying to pressurize the department lordship.
Page 48. Environmental threat. Environmental threat. Concealing receive money. The 11 and 12. That's consultant. Choice. Limits of registration is it on 17? Yes, 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 yes. It's 18. 11. 8, 17, 11, 3, assembly. Maybe. We got litigation. They were supposed to receive before the selection time.
Lordship, he has only annexed 2 documents, Lordship, that his complaints, 2 complaints, Lordship. Remaining are all documents belonging to the CW department, the minutes of the petition committee, promotion of the petitioner. Lordship.
Yes, my lord.
This vigilance, where is the reference to that vigilance case? Where is that?
Yes, it is at, we got it in the minutes of the meeting at page 169. In fact, my lord, we have brought specific allegation against these 2 officers because they never put it to the chief secretary that a vigilance case was pending. And in the month of December, the chief secretary postponed the meeting and said, you bring the vigilance report before us.
159,
169.
69. Yes.
My lord, your lordship will come at serial 11. The selection board observed that there is a regular inquiries under progress against Devajit Das, who is at serial 2 in the zone of consideration as intimated by the political and the vigilance department. But details of the case alleged charges are not furnished by them, and hence the selection board asks the PWDR to obtain details of this such and to place the same before the next selection body. And in fact, towards the end, the selection body headed by the chief secretary says, oh, the case will be again taken up on the next date. So they were trying to hide about this vigilance case, that it's prima facie clear. And the chief secretary rightly said, why will I sit in a meeting when you have not given me the details? He abstained it.
No, just a moment. I just wanted to find out this vigilance inquiry is by which authority?
By the home and the political.
Home and political.
Yes. We have made him a party.
Okay. For whom is appearing?
Government can
Lordship,
appear.
once again, I'm placing, Lordship, I'm coming to Lordship's query, Lordship, that's page 168.
Yes.
This is not something that has been hanged in the notice board, Lordship. It's taken from the file. What is the source of this document, Lordship? Has he obtained this
RTI.
by filing an RTI?
No. You file an FIR with that, for that is the different purpose. In 76, the Supreme Court has said, even if a document is brought by way of a theft, it can still be looked into by the court. If it is, that's 76, what was it, what was that case?
Well, in fact, the concept of open government was talked about in 77, 78 in the SP
That's okay,
Gupta's
but
case.
you lodge an FIR if it is wrong.
Free flow of information is the bedrock of democracy.
That's how I placed now. Their documents were obtained. It was stated in the petition that it was found on the doorstep sort of in a packet.
Malad,
Court rejected
Mr.
to
Das, every
take
time
note
don't
of those.
retaliate.
yes.
Mr. Sharma, we'll have to get an information as to whether, what is this present status of this investigation? Page 168.
Malad, Lordship is issuing notice.
Would like to see whether there's an inquiry pending.
Yes.
It's
In
over. Not before that.
Malad, there is an RTI filed on 7th of June after I approached this court, which I have annexed in the additional affidavit. And where they replied to the Home and Political, give me a reply. Page
No, it's
books.
okay, they will inform us.
Yes, they say that it is still under progress.
Okay. Wow. Mr. D.K. Das, learned counsel for the petitioner. Also heard Mr. P. Sharma, Learned Additional Senior Government Advocate, appearing for the respondent number 7 and 8, sorry, 8 and 9. 1, 8 and 9. As well as Mr. P. Nayak, Learned Standing Counsel for the PWD. Representing respondent number 3. 3 is by name. 3 is by name. We will be for 4. We have not issued, should notice now. 4, 5,
4 and 5.
4 and 5. 4 and 5. He'll be 1, 2, and 1, 2, 8 and 9. Mr. Sharma. Next paragraph. Keeping the issue reflected in the order dated 22/5/2022-24 open, court is inclined to direct the learned additional senior government advocate to inform the court about the status of regular inquiry wide RE number 78 within bracket 12 bracket close 2017, which is referred to in paragraph 11 of page 169 of the writ petition, which is a part of minutes of the selection board meeting held on 20/21/2024 of the PW within bracket R bracket close department relating to selection of officers for promotion to the rank of chief engineer, PWD. How much time? How much? 2 weeks to get a report. Okay.
Can it be before the vacation also?
Last week is very, very difficult for us to manage.
Next Monday.
We
Can
fix
it
it
be
on,
next Monday?
we fix it on 3rd of January.
3rd of January, I won't be there. I'll be on leave. No.
Okay, 6th of January?
No.
No.
First week, just Bihu, I won't be coming that time. Bihu will be a continuation of my vacation.
Oh, acha.
So can it be on Monday also?
Monday they'll not be able to get it.
Then let it be after the after the Bihu vacation.
After the January Bihu vacations on a date to be fixed by the registry.
Yes.
Just-
They'll give it in the form of an affidavit.
We just want to report, not affidavit, just
Yes, yes,
Okay.
definitely.
you give extra copy of the
Yes,
registration to him.
Now only. Only one thing I have been able to satisfy the maintainability part because that power.
We are
is-
keeping that open.
Yes, yes.
We'll
Because I had
We've
sufficiently.
not a quietest to that. Let us see what do we find there?
Yes.
We are giving this back,
Yes.
additions.
Can it be with a lordship? Because if that point is there, I can always urge.
You want us to retain it?
Yes, yes.
Okay.
Date to be listed. After.
You not fix a date, you make a mention if it is not listed.
Yes, sir. After B.
Because we don't have a
Yes, yes,
corrected calendar right now.
yes, yes. Obliged.
Item 3.
May it please your lordship.
Capital records have not come. It is received. Records. No. Yes, Ms. Begum.
It is a contested matter, lordship.
Yes.
DW 1, 2, 3 are deposited for the tribunal, and by the order 30/04/2022, the petitioner held as foreigner lordship. Petitioner's parents are voters of 1966 lordship. Voter list of 1966, annexure 6, 40, page number 42 to 43. My father is
Where is your land document?
land document at page number 64 to 65, annexure 15. This land document is in the name of my father, Rakhal Chandra Pal.
Which page?
Page number 64 is the typed copy and 65 is the vernacular one.
There's something I can't read. The page 65 I can't read. What is the year?
Yeah,
64, 65.
dated
Okay.
11.
What is the name in this page 65? I can't read.
Rakhal Chandra Pal, lordship.
Rakhal Chandra Pal.
Yes.
And
petitioner's
how have you
father.
connected yourself to this Rakhal Chandra Pal?
Rakhal Chandra Pal is my father, lordship.
How did you connect? How are you connecting you to him?
Lordship, there is a annexure 14 ration card is there, lordship, page number 62.
Page number
Page number 62,
62.
yes. That copy is in 62 and the vernacular one is in 63. Bina Pal. My name is Bina Pani Pal alias Bina Pal. I am daughter of Rakhal Chandra Pal. In the ration card, my father's, it is saying that I am daughter of Rakhal Chandra Pal. Late Rakhal Chandra Pal. My father died.
Mr. Sharma, then we give a protection to her. If this document is of 64,
5, lordship.
65.
Land document is regarding 65.
Okay, heard Miss T. Begum, learned counsel for the petitioner. Also heard Mr. G. Sharma, learned standing counsel for the Home Department, representing respondent numbers 2 and 4, as well as Mr. P. Sharma. Oh, you are there, Mr. B. Chakravarti, for CCC for respondent number 1. Mr. P. Sharma, learned additional senior government advocate for respondent number 3, and Ms. N. Bedi, learned counsel appearing on behalf of Ms. P. Barwa, standing counsel for respondent number 5. So, Mr. Sharma, you will also appear for 6 also now. For Mr. Sharma, you also had 2, 4, and 6. Next paragraph. By Filing this writ petition, the petitioner has held the opinion dated
30/04/2020.
page number
Page number 34.
34. Opinion dated 30 April 2022, passed by so and so and so and so. Reference number so and so. Which the petitioner was declared to be a foreigner post 25/3/1971 stream. Next, pursuant to order dated 25/9/2024, the records of the tribunal is received. So we peruse the record. Specifically the copy of Patta for the year 1964-65. In bracket exhibit G. Bracket closed. Next paragraph. Accordingly, issue notice returnable 4 weeks. Requisite extra copies of the writ petition within 2 days. Next paragraph. Petitioner shall appear before the Superintendent of Police, border, Gwalpara, within 10 days, below rupees 5,000 with conditions, including default clause. List after 4 weeks. Your records are received, huh?
I'm deeply obliged, Your Worship.
Item 4. Yes, item 4.
Yeah, please, Your Worship.
Which page is the opinion?
My lord, relevant portion is, my lord, is 73, my lord.
What is the best document you have to connect your to our projected
Madam,
parents?
I have annex 20 numbers of documents in my evidence on affidavit, madam. From voter list 1966.
Please come to the point. We are asking you, what is the best document? And you say you have filed 20 documents.
My lord,
Have you not seen any
1966,
person failing in the examination after writing 20 pages?
but including 1966, madam.
Please show us the document. Just come to that document. Just best document, show it to us.
My lord,
Have you seen any student failing with after writing 20 pages? You've not heard of any student writing 20 pages and fail.
But including 1966, madam.
Okay, then adjourn next week.
My lord, page number,
Next week we are taking up. If you don't understand, we are not there to give you time. Next week, be prepared. When we are asking you a specific question, do reply to that.
my lord, 1966.
It's okay. Now we are taking up next week. Post lunch. Sit. Yeah, adjourning your matter.
No, sorry, my lord.
Yes.
Item 6 for motion.
May I please, your lordship? My lord, the order impugned is at page,
This is the opinion of 2020. Let us call for the records. You are detained.
my lord,
You consider a prayer for bail on receipt of records.
my lord, we have in paragraph 23, my lord.
No, but it's still 4 years old.
My lord, we have
We'll have to check,
stated,
we'll have to check
we
the
have-
records.
we have stated, my lord, that due to poverty of the, my lord.
No,
the
that's okay, but
petitioner-
unless, without looking at the records after 4 years, we're not giving bail.
And accordingly, my lord, he sought for legal aid services, my lord, and that has been provided to him, my
No,
lord.
that we understand. You are appearing as a legal aid counsel.
Correct, my lord.
We take note of that.
And my lord, he is
Yes.
elderly person, my lord, considering his age. my
No,
lord.
not without records. Heard Mr. BK Sen. Where have you stated that you appear as a legal aid counsel?
My lord,
I think I missed that statement. You're not appearing for the Guwahati High Court legal aid as
Yes,
legal
ma'am.
counsel.
yes, my lord, I am.
Where is the statement here?
My lord, that statement perhaps, my lord, it's
Not
not
there.
here,
Okay.
but
It's okay.
my
Once
lord,
you,
I have a copy of the, my lord, letter.
no, it's okay.
forwarded-
Once you say that, we accept it.
My
We're
lord,
not doubting you.
my lord.
But Mr. BK Sen, learned legal aid counsel appearing for the petitioner, also heard. Mr. B. Chakravarti, learned CEC appearing for respondent number 1. Mr. G. Sharma, learned standing counsel for the FT matters, appearing for respondent number 2, 3, 4, and 8. And Mr. P. Sharma, learned additional senior government advocate, appearing for respondent number 5. Mr. H. Kuli on behalf of Mr. A. Ali, standing counsel for respondent number 6. District election officer, you are also appearing. 6 and 7 then. 6 and 7. Okay. State election officer, district election officer. You're not appearing for that.
5 and 7.
Okay. Oh, okay. Yeah, additional senior government advocate for respondent number 5 and 7. Okay. By filing this representation under Article 2.7, opinion dated. Which page is the opinion?
My lord, at page 55, my lord.
Opinion dated 27 to 2020.
Correct.
particular So and so and so and so, page 55. Notice extra copies within 2 days. Call for the records. Next part is the next part, the legal counsel for the petitioner has submitted that the petitioner has been taken into custody. So the prayer for bail shall be considered on receipt of the records. Next para. In the meanwhile, the petitioner, if not already deported, shall not be deported out of the country without order of the court. Next para. The learned additional senior, the learned standing counsel for the FT matters shall communicate a copy of this order to the transit camp, Matia Kualpara.
My lord, I am
Solicitor
told,
records.
I am told that he is suffering from, my lord, he has been suffering from some aged ailment, my lord. That may kindly be taken care of, my lord, by the
Just
authority.
before that, you say, the learned legal aid counsel has submitted that the petitioner is also suffering from some old age-related ailments. Most of if that be so, the Superintendent of Transit Camp, Marty Corper, shall have the medical checkup of, shall have the medical examination of the petitioner conducted and a report is sent to the court. After that, you consider the letter. Okay.
Deeply obliged. Sir.
बताइए सिर्फ
Item 7.
Please, Lordship.
Mr. Ahmed. Which page is the opinion?
My lord, page 111, Lordship. Annexure 29. Lordship.
I2. Oh, it is Nasalan.
This is a second order writ petition, Mr. Sharma,
Item 2.
protecting the petitioner. Heard Mr. M.H. Ahmed, counsel the petitioner. Mr. B. Chakraborty, on CEC for respondent number 1. Mr. G. Sharma, understanding counsel for the 50 matters representing respondent number 2, 3, and 6. And Mr. P. Sharma, additional senior government advocate for respondent number 4. And Mr. H. Kuli on behalf of the ILA for respondent number 5. Opinion dated 1/6/2024. As by so and so and so, declaring the petition to be a foreigner post 25/3/1971. Issue notice, extra copies within 2 days. Call for the records. Petitioner shall appear before the Superintendent of Police border. Which place?
Lakhimpur, Lordship.
Lakhimpur.
Lordship.
Within 10 days. Bail with all those conditions and default clause. After 4 weeks with records.
How like
10 days time to take bail.
this, Lordship. How like
Mr. BK Sen, you are there? No. In this I, right, in item 6, you write. In the same order, you can write. Later on, the learned, the court master submitted that without his permission, there's been unauthorized deletion of the provision of section 399 BNSS in the cost title of the IA. Accordingly, the court would require an explanation from the learned legal aid counsel, Mr. BK Sen, learned legal aid counsel, to explain why an unauthorized correction has been made in the cost title of this application, interlocutory application. Which shall be punished on the next date of listing.
Item 8.
May I please, your lordship?
Yes,
May I please, your lordship?
where is the opinion?
My lord, page 88, my lord. Start from his page.
So 3-year-old opinion, will consider a prayer for bail after receipt of records.
And even, my lord, the opinion even accepted, my lord, even, my lord, his case, my lord, falls under section 63A, 63, my lord. 6A3.
Shows that.
My lord, page 90, my lord. Exhibit 2, my lord. Exhibit 166 voter list, my lord, not accepted because it was certified photocopy. A second, my lord, 70 voter list was admitted and proved. Then, my lord, 85 admitted and proved with the father.
Yes.
Now, my lord, opinion, my lord, page 92. Summary has been made, my lord, 92, my lord. Clause 2, my lord. Everything has been disregarded. And impugn opinion, my lord, page 93. Nothing has been mentioned. Opinion is also, my lord, not clear.
Mr. Hari, but still as a thumb rule, you'll have to
Lost.
wait till we receive the records. Because we won't encourage a delayed challenge. You're right, you have a decent case here. Yes, Mr. Sharma. The tribunal gives a finding that the presence is there within 1970. That is before 25/3/71. With that finding, the 1970s presence is recording. Again, in para 5 says their father came in 1970. So then in this case, we'll have to grant bail then. So then we are granting bail to the petitioner. No, whatever be there, but the tribunal gives a finding that he is entered in Assam in 1970. There is a positive finding. Not once, twice, it has given a positive finding. Para 2 and para 5. Repetitive finding of 1970. Heard Mr. R. Ali, learned counsel of the petitioner. Also heard Mr. B. Chakravarti, learned CEC for respondent number 1. Mr. G. Sharma, learned standing counsel for the FT matters representing respondent number 2, 4, and 6. And Mr. H. Kuli on behalf of Mr. A. Ali for respondent number 3. And Mr. P. Sharma, an additional senior government advocate, appearing for respondent number 5. Opinion page 88, 89. Opinion dated 17/12/2021. Passed by so and so in case number so and so, arising out of so and so. By declaring the petitioner to be a foreigner of post 25/3/1971 stream. Next, the learned counsel for the petitioner has submitted that categorical finding is recorded in paragraph in paragraph 2 and 5 of the summary, to the effect that the presence of the father of the petitioner is recorded in the year 1970. Next will be the resident notice, extra copies within 2 days, call for the records. Petitioner shall appear before the superintendent of police border.
But he has been taken in custody, madam.
Is taken into custody.
Lawful.
Oh, then we'll have to wait for giving you bail. No, then, next, as the petitioner has been taken into custody, the prayer for bail shall be considered on receipt of records. Next, for the list on, give a date after reopening or there's a fixed matter. List on so and so.
8th January.
It's a.
You've been taken into custody. Bail for the custody.
Item 9.
In the meantime, the petitioner shall not be deported without the order of the court.
May please, Your Lordship. My lord, here in this case also, the petitioner is taken in custody on 2/9/2024.
2/9.
Now in detention camp Gwalpara, my lord. My lord, grandparents are Bhutar in 1965. My lord, 89 Bhutalist grandparents or parents are appearing, but although different house, but adjacent house. 89 Bhutalist, and father was examined,
Father was examined.
my lord.
Where is the evidence of father?
My lord, father's evidence, lordship will find at page 45, type copy. Photocopy at page 46. Father claimed that, my lord, petitioner is his eldest son.
But your first presence is recorded only in the, what is this of 2019?
My lord. My lord,
Okay, we'll consider a prayer for bail on receipt of records.
my lord. My lord, is
Same order.
custody, he is in custody.
We'll consider a prayer for bail
My lord.
on receipt of records. Same thing, in custody. Taken in custody on
My lord, 2/9/2024.
2/9/2024. Okay, Mr. A.R. Sigdat, I'm a counsel for the petitioner. Mr. B. Chakravarti, I'm a CEC appearing for respondent number 1. Mr. G. Sharma, standing counsel for FT matters representing respondent number 2, 4, and 5. And Mr. P. Sharma, an additional senior government advocate for respondent number 3. And Mr. M. Kuli, Ms. N. Devi on behalf of N. Bedi on behalf of Ms. P. Barwa, standing counsel for respondent number 6. Opinion page
My lord,
50.
the opinion page at page 49.
40 and 50. Opinion dated 27/2/2023, passed by so and so and so and so. And has got IMDT case number so and so. Declaring the petition to be for no post 25/3/1971 stream.
Hearing on number.
Submitted that the petitioner was taken into custody on 2/9/2024. Notice call for the records. Extra copy within 2 days. Next one.
Edition of.
Prayer for bail shall be considered on the receipt of governance records. List on same date.
Development.
The IA is there. IA for consideration of bail. Please go on, right? Right, please go on, item 15. Do I see multiple? Motion আছে কি এটা? Motion হয়ে যায়। Go back.
Item 10 for motion.
Wait, please, Your Lordship. Lordship, this is contested case, Lordship. Petitioner's father name appeared in the voter list of 1965.
We give you production or receipt of records. You are your prayer for bail will be considered on receipt of records. It's a 4-year-old
Lordship.
opinion. Miss F. Intas, learned counsel for the petitioner. Also heard Mr. B. Chakravarti, learned CGC appearing for respondent number 1. Mr. G. Sharma, standing counsel for 50 matters for the respondent number 2, 3,
And 6.
and 6. Mr. P. Sharma, additional senior government advocate for respondent number 4. And Mr. H. Kuli on behalf of AIRE for respondent number 5. Opinion dated 11/2/2020, passed by so and so and so and so. Declare the petitioner to be a foreigner of post 25/3/1971 stream. Notice extra copies within 2 days. Call for the records. Prayer for bail shall be considered on receipt of the records of the tribunal. This same day. There's a criminal habeas corpus matter, item 12. We'll take up only that and then we'll have to rise. Other matters will not be taken up in the division bench. Yes, Mr. Muzumdar.
My senior is legs on code number 5.
The additional advocate general will have to make his submissions.
As I indicated, your lord, in fact, your lordships rather indicated on the last occasion. Other points which my learned friend has raised, I find that as far as the supplying the documents are concerned, dossier, he is using the word dossier to say that, make a submission that all documents were not provided. I find, my lord, there is no substance except for the delay, my lord, in disposal of the representation.
Have you checked up? Last time we told you. In fact,
My lord,
we may not enter into that aspect,
my lord, yes, yes.
but
The representation.
strictly speaking for myself
My lord,
in the bench,
my lord,
you see, what I find is that under the CRPC,
my lord.
the requirement is only to send the those papers on which reliance is placed in the case charge sheet.
My lord,
There are similar provisions in the Assam Police Manual
yes,
with regard to the submission of charge sheet.
yes.
So therefore, apart from what is available in the charge sheet, strictly interpreting on the basis of the BNSS as well as the Assam Police Manual, I don't find there is something more than
What
what
was
is already
supplied
provided for.
Yes,
So, but we're not entering into that aspect. If only that one point is taken up.
yes. My lord, so far as the representation before the central government is concerned, I think the central government has rejected.
In the middle, the signature is also there in the middle, second page.
This was a cryptic order. Scarcity of ink in the Home Department, Department of Revenue. Scarcity of ink. And for writing these 6 lines, how much time you required? 2 months.
You're not in the front page, page number 1, you'll have to chronologically, everything has been.
No, we understand, but to write these 6 lines, you have taken 2 months.
For the that representation, we are waiting your lordship in the report for the opinion. For the report only, we were waiting your lordship. After that.
On an average, 13 to 14 lines, words in a line. 14 to 6 would be 74. For 74 words, you take 74 days. Brilliant. But this is, there's nothing, we don't find anything. What kind you have applied? It doesn't help you. 8/8/24. Okay. Anything more, Mr. Ms. Fukan, anything more? Yes, you please. Yes. Okay. Yes, Mr. Mazumdar, anything more?
But this, so far as representation part is concerned, my lord, as I lordships have seen, 30th of May. No, my lord. Whose book, my lord? Yeah, yeah, this detention orders, particularly under this PIT NDPS, I am constrained
Yes,
Lordship, I filed an affidavit in item number 14. That will be called for, Lordship.
14, okay,
May I please, Your Lordship?
yes.
I'd like to mention for listing of criminal appeal, Lordship.
Listing of criminal appeal. Okay, give it to the court master. There for listing. It's a motion matter.
Admission matter. Admission matter.
Okay,
Much okay.
yes,
Me, please, Your Lordship. Lordship, item number 18,
yes,
the office has said that it was earlier rejected by Honorable Justice P.J. Saikia,
okay.
but that fact was not informed to us. That's why we could not even
It's okay,
mention it.
it's okay.
This may go up before the appropriate bench.
Okay.
Item number 18, 1A.
Item 18, list the matter before the appropriate bench within paper. Honorable Mr. Justice P.J. Saikia.
My lord.
Okay,
Obliged.
Lordship, I beg to mention item number 17 from supplementary list. This matter may be come up after a week, my lord.
after a week.
My lord. 17 supplementary.
Case diary is available?
My lord, scan copy was called for, my lord.
Okay.
I mean,
Oh,
RTR
scan copy.
ordered.
Okay,
Yes, my lord.
okay. After a week is very difficult. Take it up any day this week. Because we come to the last week, we will not be able to take up hearing. List one, 13/12/2024.
My lord.
Yes,
Item 1, motion BA.
Bail application, Lordship. Yes, 9 is the FIR, Lordship. As on today, 24 days. Behind the Lordship. His name is not in the FIR.
you have to call for the case diary here. Because you are accused of correcting
Yes, sir.
PAN card and all from others and then using it
Finance bite.
to acquire vehicles.
Yes.
You were arrested when? 1911.
1611.
Okay. Yes. Okay, Sonapur,
Sonapur, my lord. My lord,
Yes,
short
when?
date, my lord.
Mr. Vishwa, when?
My lord, 17th, my lord.
17. June?
17th, my lord.
Opposite party.
Okay. The case diary we produced on 17/11/2020, 12/11/2012. Okay.
Obliged.
Item 2,
This item may be take. Kindly pass over the timing after some time.
After some time.
MS, contacting counsel, MHOD will appear in it.
I am to connect with Ligit process.
Item 3,
May it please, Your Lordship. Lordship, FIR page 12. The allegation is that the
where is the FIR?
page 12, my lord, that translated. Very small FIR. Now, Garlic shows the mother, my lord. In fact, there was a lab affair, my lord. This, so,
No, we'll have to call for the case diary because the girl is shown to be a minor.
my lord.
Sister on which place?
Gorchuk, my lord.
Gorchuk. Well, let the case diary be produced on
16th, my lord.
16th.
16th, my lord.
Deeply.
and providing you something.
Item 4,
Item 4,
May I please, Your Lordship? Procedural allegation against the petitioner is 376 2 and Lordship. Lordship, charge-sheeted case, Lordship, may call for the scan copy, Lordship.
My lord, POXO is there, my lord.
No, Lordship, initially it registered POXO, thereafter, Lordship, in the charge sheet, the POXO section have deleted, Lordship.
Okay. Now, let the scan copy. CRPC. IPC. IPC. From which police station?
Lordship, pending before the additional session judge court, Lordship.
Assistant Session Judge,
Kamrup, Lordship.
Kamrup.
Lotta Hill PS case number 88 of 2024, Lordship.
No, Assistant Session Judge, when you say there are several, which particular court?
Kamrup, Lordship.
There's only one?
No, Lordship, 3, Lordship. Sorry, 4, Lordship. Additional session judge court number 4, Lordship.
Guwahati,
Lordship.
That is not Kamrup, that is Kamrup Metro.
Kamrup Metro, Lordship.
Otherwise, we'll call for records from some different court and it'll never come.
Lord, sorry, Lordship.
Receive to understand the name of the court, you have to ask you
Yes,
3 times.
Sorry, Lordship.
No, what? Sorry, you have only one brief and you can't be ready with that.
Vacant, Lordship. Now proceeding is going before
No,
the.
but, you have one case.
Additional 3, Lordship.
Please don't separate. You know there's one case and then we take 3 questions from us to tell us the court. Let the scan copy of the records. Of which case? Of Sessions case number 254 of 2024. Arising out of Latasil PS case number 88 of 2024. Under section 376 within bracket 2 within bracket small n of the IPC. From the Court of Learned Additional District Additional Sessions Judge number 4, Kamrup Metro Guwahati. Next paragraph, the requisition shall be sent by email with liberty to the settlement court to send the scanned copy of the records by email for being placed before the court. Next paragraph, list on. (18/12/2024). Okay.
Oblige.
5.
Lordship, this name was arrested on 12/11/2024.
Just a moment.
Lordship.
Where is the FIR?
FIR is at page 12, Lordship, the relevant portion. Lordship. The allegation is that some miscreants have stolen a radio remote unit of Airtel mobile, Lordship, of the tower, Lordship. The present petitioner lordship, he was carrying a passenger from Guwahati towards Jamuguri lordship. And in between, when that petitioner asked the present petitioner to stop the vehicle to attend the necessary call, then the police patrolling party came therein and recovered the materials from his vehicle also. Actually, he was driving the vehicle in fact. In his vehicle, a unknown person was traveling also. He booked his vehicle from Guwahati also. And stolen goods has already been seized and recovered also. In the FIR also, lordship, the informant is making a reference of the allegation of 5/9/2024 lordship. And the FIR was lodged on 11/11/2024 lordship.
To show the ownership of the vehicle, you have not produced any document.
Yes, lordship, I failed to but I have made the statement lordship.
Statement alone will not do. We'll have to call for the records because the recording does not say that you are the owner of the car. They
So-
found you loitering with the
Lordship,
equipments.
lordship, I'll produce the lordship may allow 2 days time. I'll file an additional affidavit lordship.
Okay, on the prayer made by land council, made by Mr. Didas, land council for the petitioner. List on 11 well 2024 with liberty to the petitioner to file additional affidavit to bring on record any other document on which petitioner intends to rely upon.
Lordship. I'm okay.
Item 6.
Lordship,
Where is the FIR?
at the
Page
13, your lordship.
13.
Your lordship, the case is already charged by the concerned police station.
We'll have to call for the case diary. Which place?
Wachalangso, PS case number 49, 2024. West Karbi Anglong, Hamrin, your lordship.
Okay. Did the case diary be produced on?
Scan copy, madam.
The trial is going on.
No, your honor, but.
Charge sheet submitted, my lord.
Huh?
Charge sheet submitted, my lord.
Charge sheet submitted.
Charge sheet submitted. So we have to call for, my lord, scan copy of that. My lord, CD along with record.
Your lordship, the
Just
case is
a moment.
already behind the bar 54 days, your lordship.
Just a moment. the scanned copy of the case records relating to yes, what is the sessions? Committal is committal orders are passed? No.
No. No.
Let the case record relating to Baithalamsu PS case number 49 of 2024. In which 2024 under section 318 within bracket 4 bracket goes oblique 64 oblique 351 within bracket 2 bracket close oblique 74 of the BNS, in which charge sheet number 38 of 2024 dated 31/10/2024 was submitted by requisition from the court of which court?
West Carbengland, Hamren. Court.
Which court?
District and session judge.
The family sessions judge. You say the committal order has not been passed. You're not even stated where the matter is lying. Please find out. We'll take it up after some time. Find out from where we should call for the records. Next item.
Item 2, time being.
Madam, it's a 483 application. And in this case, madam, I'm behind the bar for last 34 days. And FIR is page 10, madam.
Where is the FIR?
It is at page 10, madam. It's a
Yeah.
type copy, madam. Yes. My lords, one prayer, madam, item number 19 is also corrected. We have filed one interlocutory application. As there are some error, madam, in our prayer, so we have got it by this IA, madam.
Item 19 to
This person is, madam, known to my father. Is a friend of my deceased father, madam.
We have to call for your case diary.
Madam.
This is from which place?
Karimganj PS. Karimganj.
Karimganj. The case diary. We'll ask for the scanned copy of case diary instead of physical copy.
My lord, that can also.
Let the scanned copy of the case diary be produced on 17/11,
My lord.
17/12,
7.
17/12.
19 is, my lord, connected. Interlocutory, my lord, we have filed in this application.
19.
Item 19, my lord. It is in the others column.
Let's just see 19. Yes, 19.
Yes, 19, my lord, it is connected to this case only because there was a typographical error in our prayer, my lord. So we have, by this interlocutory application, we have filed the corrected copy of IMN of our prayer portion. Lordship will find at page 6, my lord, annexure.
Yeah, I hear you right. But Mr. M. H. Chaudhary, learned counsel for the petition applicant. Also heard Mr. K. Bashir under the ABP for the state. Next, by filing this interlocutory application, comma, it is projected that there are certain typographical error in the prayer of the connected bail application being BA number 3716 of 2024. The learned counsel for the applicant praised that the prayer made in Annexure A to this interlocutory application be read in the context of the prayer made in BA number 3716 of 2024. Full stop. Next paragraph. Heard the learned APP in the matter. Next paragraph. In view of the statement that there was a typographic error in the prayer of the connected bail application, comma, this interlocutory application stands allowed. The prayer contained in Annexure A of this interlocutory application shall be read in view of the prayer made in the connected BA number 3716 of 2024. So this interlocutory application stands disposed of.
I'm deeply objecting.
Yes, item 7.
Right, please, Lordship, my lord. Is there 4 NPT application, my lord?
Where is the FIR?
FIR, Lordship, fine, page 13, my lord. Here, Lordship, find that, my lord, one examination was going on, my lord, for the recruitment of UB and AB constable, my lord. And my lord, while verification of documents, my lord, Lordship, find, my lord.
We'll have to call for the case diary here. It's a case of manifesting fraudulent document.
But here, my lord, with all respect, my lord, should find, my lord, that one that was submitted by Nobojit Roy, my lord. He has been arrested, my lord. He submitted the alleged forged documents, my lord. And last line, Lord, my lord, Lord should find, my lord. My name, my lord, it appears, my lord, around 5 lines, my lord. Above, my lord, as the aforesaid documents are suspected to be fake. So
Provided to him by his cousin brother.
my lord, you true, kindly see, my lord. But we got it from different person through one of his friend, my lord.
We don't know what if it's a case of fake document in the recruitment of UB and AB constable.
My lord, here he is a employee, my lord. If you kindly have a look, my lord, at is 14, my lord. He did not forge, my lord. Even if I assume, my lord, the allegation, he did not forge and he did not use it also. And allegation
know,
also
because
that
if
he
it's
got
a
it from
first-
different person, my lord, not from the petitioner, my lord. Statement of co-accuse that too from a different person. Case
Still, we have to look at the case diary.
Here, my lord, he is a service person, if possible, my lord. Otherwise, I leave it to your lordship, my lord. Page 14, my lord.
I
kindly
must-
have a-
You see, somebody is alleging your name.
Through me, my lord, that is the, and my lord, these are 7 years offenses, my lord.
I understand, but still.
No, my lord, notice yet served, my lord. So they could have served notice also, my lord, under 35(3), my lord, like 41A, my lord, now. So that part is also there, my lord. If possible, kindly protect, he will appear and he will give a statement, if possible. Rest I leave it to your lordship, my lord. Otherwise, I don't think he's a government.
You know, manufactured documents very difficult.
My lord,
to get
FIR
there.
name is my lord, this is the FIR name. Really
With
stated,
the,
my lord.
Let the case diary be produced on case diary or scan copy. This from which place?
This is
My lord, Kopraja.
The case diary or scan copy thereof be produced on 17/11/2024. Get scan copies this time.
Scan copy.
Because
we can renew our prayer on that bill.
Yes.
Problem.
Item 8.
May I please your lordship, 482 application, FIR is at page 10.
Lordship, Madam, may possible for the time being.
You
Special
are-
page in court number 3, Lordship,
Oh, acha, this is
CBI,
CBI matter. Okay.
yes,
Okay.
after something. I'm like,
Item 9. Item 9.
Yes, may I please, your lordship? Is a prayer is paid, 482. My lord, FIR is that your lordship will get the page, my lord, 11. It is a quarrel between the same family members. Kitchen is different, but they belong to same.
But somebody is died.
Yes, my lord. Now, my lord, because the passage of the water, my lord, there is a quarrel between the initially by the woman, thereafter male person has intervened in the matter, and the allegation is there was a marpit, my lord. And after 5 days, my lord, the affair was lost, and one lady was taken to the Fakhruddin Ali Ahmed Medical College, where she allegedly succumbed to injuries. To our information, she did not sustain any injuries, but she was ailing, my lord. She died and she had a natural death, my lord. Now, my lord, in this case, my lord, we have approached to the learned court below for a serious bail, but it has been rejected. I have annexed the order.
Yes,
But
yes, in that case.
only agony 103 has been added. Subsequently.
কিন্তু আমার একটু করতে লাগে এই অর্ডার শিটটা আমি পাইছি কারণ এই দুই ডেট লিখে টাইপ করে দিতে তোমাদের বিষয় এবং করে এত আমি বাকি কি ব্যবস্থা লাগালে তুমি কষ্ট করবে তা আমিও কষ্ট করবো আমার মধ্যে তোমার কথা থাকিও লাগে এর আইসে এই পরে ওর সামনে থ্যাংক ইউ নিবো লাগে থ্যাংক ইউ নিবো
Borpeta.
Yes, madam. And one of the women, my lord, of this has been granted bail considering her delivery of the child, my lord. And there are two women applicant before your lordship also. We are also praying that if any protection be given, especially these two women, my lord, till the calling of the CD, my lord. We have already taken into custody also. They are in jail, my lord.
You see, let's call for the case diary. Let the let the case diary, including the as well as the postmortem report containing medical opinion of death, comma, or scan copy thereof be produced on
May I pray
16?
19th person.
19th. 19th is we are-
Your lordship is fixing 16th, but I have got no objection.
16 12/2024. Get a scan copy. All this, whether even if I forget to write this scan copy, get a scan copy.
It
Scan
includes, I
copies.
think, medical report, postmortem.
Item 10.
My please, Lord. Here in page 8 is the FIR, Lord.
Where is the FIR?
Page 8, Lord.
The allegation is case 8, Your Lordship. Allegation is regarding kidnapping of the minor daughter of the informer.
Yes.
And that allegation is in respect of the accused number 1, Your Lordship. In the present petitioner, he is the accused number 2. And allegation against the petitioner number 2, the petitioner is that he helped the accused number 1.
Then we have to call for the case diary because the girl appears to be a minor, 13 years.
In the meantime, she has already been recovered, Your Lordship. But my role is, Your Lordship, in the affair, he stated that
No, it's a
I
case of-
only helped the accused number 1.
No, whatever be.
But
let me
regarding the
see
kidnapping, that is against the petition accused number 1. So therefore,
it's-
Your Lordship, I am praying, Your Lordship, protection may be given. Your
No, it's a girl of 13 years. I'm not threatening you for the time being. At the case diary, along with the statement of the victim girl, comma, if recorded. Or scanned copy thereof be produced. On this is from which place?
This is Panbari, Your Lordship.
Banbari.
Sirang.
Chirang. 18/12/2024.
Oblige.
Item 11.
May I please, Your Lordship? Lordship, it's a 482 application. Lordship, will come to page 7, Lordship. Fire, Lordship.
Page number 7.
7, Lordship. The allegation is that, Lordship, there was some dispute between the owner of the brick kiln and the laborers, Lordship. And during that, Lordship,
Just a moment.
one of the labor died, Lordship. But
Who are you?
I am one of the owner, Lordship. Name in the FIR, Lordship.
Call for the case diary then.
Allow me to postmortem because
Let
that
me-
because of some chest pain, he felt discomfort in breathing, Lordship, and he died. As per the allegation, he could kosto pai in the allegation, Lordship. He was taken to the hospital and he died.
Let the case diary along with postmortem report, comma, if available, or scanned copy thereof be produced on. This is from which place?
It's from
Dorong, my lord.
Durham.
Dhula, Lordship. It's in Durham district.
18/12/2024.
My lord, only my one prayer, my lord.
Yes.
My lord, or scan copy, my lord. My lord.
We have added scan copy.
Yes, my lord. Because my lord, in many cases, my lord, as because when investigation is going on, my lord, they're afraid of to make a scan copy in those cases. In some cases, my
No, it's okay. We want the scan
Yeah.
copy.
Oh.
Let's
Here
look
also
out.
postmortem.
In fact,
clarify
we had
everything.
requested your authorities. You don't know whether it has happened.
my lord.
It should have been available in the in your portal by now. We did not have to call it also. You see, just you have your mobile
Yes,
with
my
you.
lord.
Just open up Gujarat High Court, for example.
Yes, my lord.
In the drop-down chatbot, you will find FIRs. Even this is in most of the courts now. Punjab, Haryana, Gujarat, Kerala.
Here also EFIRs are available, Lordship. But I don't know whether postmortem is available.
No, we don't know because we must also learn how to operate. It may be available, but we may not be knowing how to operate. So they will have to tell us.
My lord.
You've seen that there's a column FIR in the drop-down box. Because once we make it available in the ICGS portal, then it will come into
Yes.
our system.
Yes, my lord.
Because if FIR is something in ICGS portal, we can access it.
Yes. That can be done. my lord. Yes.
It becomes easier
Yes.
because it takes up a lot of energy of the police personnel to send people here and there with
Minor,
the say
minor.
case diary.
Minor.
Um, Whenever I said FIR, call for the FIR, you add scan copy, huh? Everywhere in all the orders. Or so and so. This is from which place?
It's from Dhula in Durham district.
So wrong. 18/12/2024.
Postmortem lordship as well.
Yeah, wait. I said postmortem. Yes.
Item 12.
May I please, Your Lordship, 482 petition, Lordship, SR at
Yes.
page 9.
Page 9.
Lordship.
Okay, to the case diary.
Protection.
Medical report, if any. Or scan copies thereof be produced on the next date of be produced on. This is from which place?
Lordship, it is Tamalhat.
Dhubri.
Dhubri.
Amarhat. 17/12/2024. Okay.
Lordship, protection.
We are not protecting you. You give an explanation which we find may not be entitling you because you show your presence there. Right, Vinay, Bishop की कोड में. Yes, item
Item 13.
13.
Well, application, madam, Your Lordship will find FIR takes lane, madam. Only 2 sections are non-bailable, others are all bailable, my lord. 74 BNS and 143 are non-bailable, my lord.
We have to call for the case diary here.
Para 6 and 7 is my case, my lord. Yeah,
Para?
and para 6 and 7, my lord. In my explanation, my lord. And my lord, I am the owner of the Bicklin industry, my lord. Very interestingly, my lord, this FI was written in English, and who has written not been even mentioned. And the person who, my lord, I lost the asset putting, my lord, thumb impression, my lord. They are taking money from me to, my lord, for an advance in the name of work in my baking industry, my lord. Now, my lord, neither they return the money, nor, my lord, they come to my lord. So I asked them explanation from them why. The para 6 and 7 is my case, my lord. BNS for who option? Page 74. Lordship, my lord, section 70. That's 74, my lord, BNS. So ingredients, my lord,
No, but these alleging that there's been
what in here?
assaulted, went to medical. Let us have the medical report. Did the case diary along with medical examination report of the victim, if corrected, or scan copy thereof be produced on 16 next Monday.
So I will be protected, my lord, for 60.
No, because if he's been assaulted and he's in hospital, that is the projection. 16th will see.
My lord.
You're getting scan copies.
Even my lord, that's why I am submitting, my lord, he put, he put some impatient. And my lord, it is written in English. And who has written this FIR, that is also not disclosed, my lord.
It's okay, they have manufactured it.
My lord. Okay.
Maybe there's a good lawyer behind them.
My lord. On 16, right?
Yes, Mr. Chaudhary, your matter.
Yes, Lord. They filed the affidavit finally.
They'll issue a formal letter. So we wait for a week.
Yes.
Let them do it on their own. Last page, they said that they're issuing a letter to the APSC.
No, that is regarding, my lord, advertisement, my lord.
Oh.
So, your lordship. can-
No, I think if your lordship reads the para as a whole, now they say, my lord, once APSC forwards it, they will do it.
Huh.
No. Yes, correct.
Some vacancies are kept vacant in view of the interim orders. And they've not
That the
been
deputy
included.
begs to state that the Assam Public Service Commission
They have not
fine.
been included.
Huh?
They have not been included, so they are protecting you.
Yes, yes. They've kept some.
Post vacant and they are
Yes.
not being advertised,
Yes,
for which letters are being
So
issued to
now,
the.
based on this, I think lordship will direct the APSC to forward our name.
I cannot forward it, my lord. That is the problem, my lord. Your lordship kindly see that.
No, let them send a letter to you first. You'll have to take a decision.
Regarding the last line, my lord.
You'll have to take a call.
My lord.
So if it amicably happens,
Yeah, no,
well and
that's
good,
why I'm
otherwise.
submitting, my lord. If it is confined only to the petitioners and those who are pending cases, my lord, no problem. Because enough poster vacancy there. Our problem is that we cannot go beyond 290. Already we recommended 290. If additional list I have to submit, my lord, it will recast. If he recast, my lord, 37 more candidates will come, my lord. So that will be trouble. So
It's
that's why
okay.
if
Let
it's
them send you a
confined
letter.
only to the petitioners and the person who opposes this honorable court, then my lord, everything will be settled.
You are raising a right issue, but we'll have to take a call. Let that
My lord,
letter
my lord, definitely.
But my lord, there are instances where honorable court has given relief to the petitioners also. In so many other matters, my lord. Anyway, let us see how they react.
How they deal with it. Because unless there's a clarity in their letter,
Yes.
we don't even know what will happen.
No, they clearly say that they have earmarked some posts.
No,
Once,
but in the letter to be sent to them, what they actually say is,
Lordship, in fact, from my knowledge, Lordship, the letter would be Lordship containing Lordship that with the
no, you see, Mr. Upadhyay, while dealing with the government, we have seen there's a lot of slip between the.
what they profess and what they say.
No, between the cup and the lip. That is the correct expression. There are slip many times. Okay. Mr. T.J. Monto, Learned Senior Counsel, assisted by Ms. P. Barwa, P. Sharma, Learned Counsel appearing for the UPSC, APSC, as well as Mr. K. N. Chaudhary, Learned Senior Counsel, assisted by Mrs. D.J. Das, Learned Counsel for the private respondents. Next para. Mr. N. Upadhyay, Learned Standing Counsel for the Irrigation Department has referred to the stand taken in the affidavit filed on behalf of respondent numbers 4 and 5 and submits that the Irrigation Department is expeditiously taking steps as steps, as stated in paragraph 4 of the said affidavit. Full stop. Next, accordingly, the matter stands adjourned today. List again on.
It can be on 17th or 18th, Miller.
We're fixing it on 16th.
Miller.
Because last week.
Miller, 16, I have some difficulty. Can it be any date other than 16, Miller? 17, 18?
17? Sorry.
Is it Tuesday?
No, 18, 12. Okay. Okay, 17.
Miller.
17, 12. Okay.
Deepler.
Deepler.
Yes, item 15.
Minors is a review application. And we have filed an IA also, but after filing minors, I did some research and I came across a judgment, limitation in case of review doesn't come. So the IA, if Lordship allows, it goes, but it condones a delay of almost 72 or 729 days.
What is the judgment you are referring to?
It's my I'm giving this Kanak Chandra Sharma. Our High Court minutes. 1995 1 GLI.
You have a copy?
Yes, I have. Paragraph 5 and 6 there in.
Yes, okay.
Also, my lord allows that IA.
No, I'm not allowing without notice.
Oh, let the,
And application of condemnation or delay.
my lord, let him come, my lord. Let the person come.
Okay, but Mr. D. Gogoi, learned counsel for the applicant. So issue notice on this interrogatory application by which it is made for condemning the delay of 799 days.
729 days.
No, I'm reading 29. I don't read 79, 99,
Yes, 729 months.
799.
I may be wrong, I just calculated. But okay, man.
No, I don't know. You're writing here
Oh.
799.
My
Look
lord,
at this.
it may be correct. man.
It will
799 can be correct.
beyond the period limitation in filing the connected review petition.
29.
Full stop. The applicant shall take steps within 2 days for service of notice on the respondents by registered post PVD. Anyone to be served by Dasti?
We can serve the petitioner or the opposite party. man. Let us serve. man. Then, my lord, let be 1 week. man.
Okay. In addition, the applicant is also granted liberty to serve notice by way of Dasti on the respondents. And upon service, an affidavit of service shall be filed prior to the next date of listing. Next list on 3rd of January 2024. Fine.
Oh,
Keep it there. Keep it
it's
there.
correct one, 799. My copy ink spill, my lord. Oh, look.
Time being item 6.
Court name is Special Judge West Carving.
Which court?
Special Judge West Carving Hamrin.
Special judge.
Yes.
Where do you find that name?
Page 25 years.
20?
Height.
Oh, no. Something is wrong.
This is the bail rejection
This is
order.
bail rejection order.
Commit নহলে যে commit হৈছে তেতিয়াহলে ক'ত আছে কোনখন মেজিষ্ট্ৰেটৰ কোৰ্টত আছে সেইটো খবৰটো লৈ দিবে
List the matter on day after tomorrow. Today is Wednesday. List on 11/12/2024. On which date the learned counsel of the petitioner shall inform the court as to from which court the record is required to be called for.
Item 8.
Please, your lordship, 482 application. File is at page 10. Against allegation against one Mintu Das.
Page number?
Page number 10.
Mr. Busho, what we can do? These laws, they disturb the flow and irritate us in such an extent.
My lord, I have.
That we have to intervene. It takes some time to cool down. No, you can't do anything. I'm just expressing because if I say it out, then my pressure comes down.
Yes.
Nothing like that. We were not such foolish even on the first day in in the court. Even on the first day in my life in this court, I was not that foolish that I would not know the name of the court from where record is required to be called for. He's looking at the bail order and saying call for the records from that court. Charge sheet is submitted where we don't know. We have to call for the records from which court he does not know. He's referring to a bail order, rejection order of earlier court, which is by special judge, says that call records from that court. Yes,
Page 10.
Page 10. Just a moment. We'll have to call for the records. You can't.
I'm the wife of Mintu Das.
Petitioner is also managing director of the company who is taking the money from the public, lordship.
We'll produce the
Lordship, case diary, lordship.
case diary.
Lordship.
You have it?
No, today is the first day. It
Or
was
today is first day?
If possible, she's a lady. She has to appear because she has been served notice on 6th. Lordship, the main accused has been arrested, Lordship. And she
You
was.
can't say because this is that series of
Yes, Lordship. I
those
leave it
cases.
to your Lordship.
Series of those cases where
Yes, Lordship. I leave it to your Lordship.
Is absconding from January, lordship, with her husband.
no, not that. See, absconding or not doesn't affect us. But yesterday in the headline you found we see another scam of 200 crore.
Yes, every now and then when your lordship it's on the TV, lordship, you see lordship scams are going on, lordship. People are
If people are ready with that kind of money,
Exactly,
what is
so
the harm
easy
in
money.
taking it?
Easy money.
Is it not?
Easy money, lordship.
Some of
No,
our
it's not a
colleagues
question of
are
easy
also-
money.
Some of our,
Because you see, when people are there to deposit,
Lordship.
what is wrong?
some of our colleagues are also investing.
Huh?
Some of our colleagues are also investing in these trading accounts.
Is it?
Yes, but they by opening a demat account on their own name. Because they have now become conscious. Lordship. We do not give money to the others.
Okay, the case diary or scan copy thereof we produced on 17.
Let it be on 18, lordship. 17, lots of cases have been already fixed.
18 to
Then make it
19.
16
Lordship.
because 19
let
then
it be
19
19.
we have fixed matters.
19.
19, lordship.
Huh?
19.
On 19, they are also 19.
19.
19.
19.
Thursday. Hearing day, lordship.
No, every day is hearing day in the last week,
19.
but it is very close to
Last day.
19 will be appropriate because of
very,
cases.
very close to.
See, AD, lordship.
Okay, 1912.
Deeply obliged.
This will be available in Guwahati or?
Lordship,
Yes.
it will be an RC case. We have referred
Actually,
to.
case has been investigated by EO3, Economic Offence Wing of Delhi, CBI Delhi, lordship.
So this record will come from Delhi.
The records are here because courts are here, lordship. The IO will have to, sometime he is to stay here and again go back, likewise, lordship, they are maintaining.
Now the IO is here, Lordship, because with the main accused. He has been.
Today is here. Today he is here
Here.
because we have filed an objection also today, lordship. That has not come on record.
Okay, because last days we are very worried about, we have a fixed matter on 18th and 19th, that's right. Okay, 19th then.
19. Deeply obliged.
Highly.
Please, when you are producing case like this, flag mark the relevant part.
Yes. Perhaps if I'm not wrong, it's initial stage, I don't think there will be any material against her.
No, we don't know, but whatever is
yes.
there, please flag it.
Yes, sure.
We'll get very less time on that day.
Yes, sure.
Item 16, bail hearing BA.
May not, lordship, may be also present. My lordship, I just
No, it's okay.
may present also, lordship.
It's okay. Yes, you have.
My lord, CD available with us, my lord. It is actually a matter of 2010, my lord, the incident.
Huh.
And the person who is, my lord, now arrested present petitioner, it is in 2024, my lord.
Yes.
Yes, my lord. Actually, the case is here that, my lord, a boy, he was missing, my lord. On the basis of that, the FIR was lodged, my lord.
Is the boy found out? No.
No, my lord, till not.
Still
I
not.
have gone through the CD, my lord, but I didn't get because he was many persons as my lord arrested even, but not. Here only their submission is that they stated one Dinesh is there He is not that person. And according to police, alias Dinesh, alias this person is one and same.
Okay, and who is this Salahuddin Chaudhary?
My lord, Salahuddin Chaudhary, alias Junaid, my lord, alias Junaid. My lord, there was a, my lord, mobile phone with the victim boy, my lord.
Yes,
That
it
was
was
my
found
lord.
out with the mechanic.
Yes, my lord, that was found from the mechanic, my lord. On then after interrogation, he said that he bought it from another person. Then again from interrogation came to know that one person, that is the mechanic, he is Dinesh Chaudhary. my
Dinesh
lord.
Chaudhary, yes.
Dinesh Chaudhary, from whom that was recovered, my lord.
Yes.
Now, my lord, they tried to find him out, but he, as per the investigation, he is a very sharp person. He used to change his mobile SIM card. Finally, they are able to get their IMEA number of the mobile, and on the basis of that, they nabbed this person.
This person.
And from the sources, they came to know the Salahuddin Chaudhary, alias Junaid, alias Dinesh Chaudhary.
Oh, okay.
Now their contention is that I am not, I am Salahuddin Chaudhary. I don't know Dinesh Chaudhary.
He was arrested when?
He was arrested, my lord, on arrested on my lord 4/9/2024, my lord.
4/9.
4/9/2024.
It's almost 3 months.
My lord. And they made a investigating agency, my lord, made a prayer, because from during the course of interrogation, my lord, he took another person's name, and where they stated that that person has a criminal background. Maybe that is the same nexus, but, the boy was not, my lord.
No, but he is entitled to get a default bill now.
My lord.
Charge sheet has not been submitted.
My lord, not submitted, my lord. Charge sheet not
So if you
submitted.
grant an,
My lord.
grant a bail.
That
Because
part.
if charge sheet is not there, you can't help it. None appears on call for the petitioner. However, Mr. K. Bushel under the APP has produced the case diary. Next, brother. The petitioner, namely Salahuddin Chaudhary alias Junaid, page 2, was been arrested on 4/9/2024 in connection with Bosito PS case number 664 of 2010 under section 365/358/364 capital A IPC is praying for bail under section 483 of BNSS. Next one. The learned APP has produced the case diary, which reveals sufficient incriminating materials against the petitioner. Full stop. It also appears that the missing person, who is the informant's son, was found missing since 11 a.m. on 12/12/2010. Full stop. They said missing person had a mobile, and after tracking of the said mobile through its IMEI number, the same was traced to the petitioner. First of the investigation reveals that the petitioner uses the alias of Salahuddin Chaudhary alias Junaid, Juneth, page 2, as well as Dinesh Chaudhary, DINESH, Chaudhary, CHOUDHURY. Full stop. Be there as it may, having taken note of the fact that the petitioner was arrested on 4/9/2024, and since then he is in custody till date, the petition is found entitled, full stop, as charge sheet has not yet been submitted, the court is of the considered opinion that the petitioner has become entitled to default bail in terms of the provisions of, what is that new, I don't remember, 190s. 72AB. Earlier it was default bill provision was
My lord, 167.
167.
2. my lord.
Now it is 187.
Yes.
Just had
187.
petitioner assessment so and so is advanced till date, comma, even assuming that the
Yes, my lord, 187 3, my lord.
assuming that
187.
any charges that may be framed against the petitioner would be under would be as a sessions tribal case, comma, still he would be entitled to a default bail within the default bail by applying the provision of section 180.
187, my lord, 3, my lord.
187 within bracket 3 of the BNSS, comma, 2003. Next further. Accordingly, this application stands allowed. Post of the
My lord, only my humble submission, my lord. One prayer is there, my lord. Because my lord, may kindly see in the case diary, whenever they produce the report, my lord, they are only prayer from the side of police, my lord, what I have understood. Because this man, my lord, used to change his address along with some condition maybe, my lord, issued so that he will be, my lord, during the course of trial.
It is
also.
granted to the petitioner in the following conditions. One, the petitioner shall furnish a bail bond of rupees 20,000 with one surety of like amount to the two surety of like amount to the satisfaction of the learned Chief Judicial Magistrate. Which place?
Chief Judicial
No,
Magistrate,
this
my
will
lord,
be
Kamrup Metro, my lord.
Kamrup Metro.
Kamrup Metro, my lord.
Okay, Kamrup Metro, Guwahati.
Guwahati, my lord.
Just stop. As a condition of bail, it is provided that the petitioner shall appear before the IO once a month till his personal appearance is dispensed with or charge sheet is submitted, comma, whichever is earlier. Next, in the event the petitioner fails to appear before the IO, it would be open to the IO to move the jurisdictional court for cancellation of bail. Next, there are other conditions also, 2 or 3 conditions. Take it from Chapakor, from Chapakor, from Muna. Next para. It is also, it would also be pertinent to state here that today when this order is passed, the petitioner is unrepresented. Next para, the case diary is written. So none of the call case that is not required. Let the case diary be returned. Please.